Bill Schmick. Welcome to 30 Minutes.
A will is the place where you specify to your family how you want things to go when you pass away. And it's important that each person have a will, because if you don't have a will, it goes according to what's called intestate. The state decides where your things should go. You don't decide. The state decides according to their standards who gets what. But in your own will, you can specify who gets what. And that's important to have. But an interesting part of the will is something called the executor or executrix. Each of us who has a will identify a person to carry out our wishes when we die.
Okay.
And that's a difficult job. They have to keep track of any debts that we have, any assets that we have, who we expect to get what. If there's cash, they need to set up cash accounts to hold assets. They need to pay bills. They need to do a lot of detailed work. And the person who is that executor or executrix needs to be prepared to do that. So one of the first things you should do, number one, is find out where your will is, and if it exists.
If it exists.
And write down in your life folio, in the back of my book.
Which one?
The first book called Can We Talk? There's a section in the back of that book called the life folio,
right,
where you write down where all your important documents are.
Okay.
And you write down where your will is and who the executor is.
Okay.
Because what people have found out, let's say your mom who's 92 has a will, and the person that she might have identified as the executor has passed away.
Yeah.
Is no longer even alive. It might have been her lawyer or a friend or someone else. So that needs to be changed.
Now, another question there. We mentioned in the last broadcast about alpha childs, and I happen to be the alpha child for the family meeting and getting it together and so forth. That doesn't necessarily make me the executor of the will, because from what you've said, even though I'm a business person, so yeah, I know assets, debts, income flows, and so forth. But my brother may not be. He may be a computer programmer. So I guess you're saying that whoever it is has to have some background in this kind of stuff.
The person who has that role needs to be detail-oriented.
Okay.
The person that can follow every little single detail of your mom's estate to know where everything is and to record it and keep track of it. Because they're going to have to pass that information on to the probate court.
I see.
All of your assets that do not pass via joint tenancy or via beneficiary statements, if they're in your personal name, go through probate. And the probate court has to examine all those assets, and they also determine if you have any outstanding debts or liabilities, and they want to make sure, and the executor's job is to make sure those are paid before they distribute any assets to the family. So all these things need to be taken care of by the executor.
So it doesn't necessarily have to be a family member.
No. In many cases, it's not.
Really?
It might be a family advisor, it might be a financial advisor, it might be an attorney, it might be an accountant, someone who's familiar with that job and can do it. And some families have actually hired professionals to do that work, and they charge anywhere from 3 to 4% of the estate to do that work, if they're not a family member. But you can pay a family member to do that work as part of settling the estate. But that's important to have that done and have the will specify who the executor is and a person that you know. And the adult children need to know who that person is, because they're going to be dealing with that person when mom passes away.
I see.
They're going to have to know who that person is.
Okay.
So that's critical.
Right.
But while a person is still alive, there's another document that is just as important, if not more important. That's called the durable power of attorney.
Wait a minute, before we go there, on a will, how detailed is a will? Is it that I say, and I'm thinking about my own will, because it was sort of like, I'm going to leave all my real estate assets, it's my house, okay, or my whatever IRAs or whatever to my daughter, okay, period. I don't go into it.
You don't need to go into extreme detail, especially with your tangible assets. If you
don't.
have collections and various articles, you can specify, and my tangible assets I leave to. Or you can have what's called a codicil attached to the will that specifies what happens to individual items. That can be
Okay.
added to the will as a codicil or a letter that is added to the will to specify those specifics. It does not have to be in the will itself, because those items can change over time.
Okay.
And you can change that. But the general qualities of the will need to be specified. My real estate I leave to, or I leave this property to and that property to, and my tangible assets I leave to, or according to my codicil and the letter attached to this will.
Should my wife also, is it a will for me and my wife?
Now, each
or-
person has their own will.
Oh, really?
Each person has their own specifics.
Why? Why?
And because your assets may be different from your wife's.
Okay.
And what you own may be different from what she owns.
True.
And each one of you may specify that you want different things done with your assets if you pass away. She may have jewelry that she wants to
She
go
does.
to certain family
Yes.
members.
So,
And you may have an automobile or something that you want to go to a certain person.
so this is in the, what do you call it, a codicil that
Yeah,
is
codicil,
attached?
Kodocil is a codicil, or it's a letter attached to the will if you want to get more specific.
I see. Okay.
And that can change over time.
All right.
So the will is the first and primary document that everyone needs to have. The second is,
Well, where do you get it?
well, there's lots of different places. What I recommend mostly is you work with an attorney in your state who's familiar with your state laws.
Because?
Various states have various rules regarding succession.
Oh,
For example, in Massachusetts, you need to have almost $5.5 million to pay federal estate tax, but you only need $1 million to have to pay state succession tax. So if you die in Massachusetts with $1 million in your name,
yeah.
and $1,000,001, you have to pay a succession tax to the state of Massachusetts for those assets in your name. So it's important that you plan ahead so that hopefully those assets aren't in your name when you pass, so that you don't have to pay that tax.
Got it.
But each state is different. Some states have no succession tax, some states do. There is a federal estate tax, but the federal estate tax, it's been raised to $5.45 million now. So it's
see.
a big number.
You know, I meant to ask you in the last session about, well, in this case, it's my mother, or my father who's passed. If he had a life insurance policy, for example, that I didn't know about, she didn't know about, or some other assets, is there any sort of national or a state organization that I could go to and find out if there's any hidden assets that I don't know about?
Unfortunately, unlike cash and other bank accounts,
Yeah.
there's no system that tracks life insurance beneficiaries. Now, if you can't find your life insurance policies, you can contact the company and they'll issue a replacement policy. When I was updating my life folio recently, I discovered that I couldn't find my wife's life insurance policy. So I called the insurance company, and within 2 weeks, she signed a form indicating that she could not find the policy, and they sent her a replacement policy, exactly like the original policy. And now we have the policy in our file, and we know where it is, so we can, if she passes, we know what to do. But you need to find out, first of all, do you have life insurance, and where is it? And thirdly, who are the beneficiaries? But there is no standard or no organization that will track for you if you're a beneficiary of a policy other than the insurance company that you bought the policy from.
So back to the will. How I should get it drafted by a lawyer in my state.
In the state that you live in.
How much is it going to cost me?
Well, it can vary. And if it's not extensive, it might cost $300, something like that. If you have trusts and you have a larger estate and it's more complicated, it can cost $1,000, $1,500, but it's worth it because you want to avoid any potential taxes that you might incur.
Sure. So what's next after the will?
Something that's more important while you're alive is something called the durable power of attorney. Now,
sounds complicated.
Yeah, if you or I was no longer capable of writing checks, let's say that we had a serious automobile accident and we were incapacitated, if we have accounts in our name,
like a checking account,
or an investment account,
yeah,
no one else can act in our behalf unless they have the durable power of attorney.
Okay.
Now, joint accounts, it's fine. If you have a joint account with your wife and you're incapacitated, she can handle it for you. She can do it.
Okay.
But if it's a personal account in your name, she can't act in your behalf. I had one situation with a client who was a retired doctor who unfortunately had a very serious stroke, and he was in a rehab facility, and his wife started writing checks from his account. Well, she was his second wife, and his children from his first marriage somehow found out that he was incapacitated and she was writing checks. They went to the court and had her called to the court and stopped her from being able to write checks because she did not have that durable power of attorney. She did not have the authority to act in his behalf.
Okay.
So she had to go through a 5-week process of proving that her husband was incompetent before they would give her the title conservator to be able to act in his behalf. But if she had just gotten, while he was healthy, and both signed a durable power of attorney, giving each other the power to act in each other's behalf, she never would have had that problem.
Now, does this durable power of attorney apply to things like brokerage accounts, trusts?
Any type of investment account that person has authority over, the durable power has that same authority. Now, there's ways to make it triggered if you're incapacitated. There's something called a springing power, which means that it only comes into effect if you're incapacitated or mentally incompetent.
Okay.
That is more restrictive, and the doctors have to prove that you're incompetent before that can take place. But a normal durable power of attorney, immediately at any point in time, that person who has that power can act in your behalf for you. Now, you certainly want to make sure that you trust that person.
Yeah,
You know who that person is. It's someone you trust. So each of you, husband and wife, should have the power on each other. But a third person should, or even two other people, should have the powers on each of you.
On each other. So my wife has it on me, I have it on her.
And then you should have another person that has it. Could be your daughter,
my daughter,
or could be an associate, or another family member should have that power to act in your behalf.
Okay.
Because if they don't, your hands are tied. There's nothing that you can do to handle your funds if you're incapacitated.
Okay.
But that's more important in many cases than the will, because it's needed while you're alive. Something similar to the durable power is something called the healthcare proxy. It's the same thing as the durable power of attorney, but it only comes into effect regarding healthcare. So let's say, for example, again, you were in an automobile accident, you were in the hospital, and you were in a coma, and the doctor needed to decide what to do.
Whether to pull the plug, you mean?
Or operate, or what to do.
Okay.
The doctor would go to your healthcare proxy and say, here's the situation. What will you allow me to operate or not? And that healthcare proxy, based upon their understanding of what you want, can make that decision.
Oh, so that's a little confusing to me because as everyone knows, I got a new knee. But before the operation, they had a form and everything that I filled out, and my wife was there and signed it, which gave her the authority if something happened. to me while I was getting the operation. That's different than
That was probably, I'm not sure if that was, I don't think that was a healthcare proxy.
Okay.
I think that might have been a HIPAA form. That means
Okay.
that the hospital can release information to her.
Okay.
Even I remember going into the hospital and asking about my mom's status, and they wouldn't reveal certain information to me because my mom had not signed the HIPAA form, which is a form that authorizes the hospital to give healthcare information to another person.
So this healthcare proxy should be done at the same time as the durable power of attorney,
Yes, right. And as we mentioned in the first session, one of the best ways that I know of to do the healthcare proxy is through the 5 wishes. Because the 5 wishes, right, the 5 wishes specifies who you want to make decisions if you're not able to. And you name that person in the 5 wishes.
Right, the person I want to make care decisions for me when I can't.
Right.
Okay.
That's the healthcare proxy.
Okay.
Because it's important that person understand what you want. And that's why you want to do it in conjunction with the living will. Because in the living will is not a legal document in itself. It's not a legal document. But the healthcare proxy can read your living will and say, all right, in this circumstance, he does not want to be kept alive, or he does not want to be kept on medical recovery.
Okay.
That's the healthcare proxy's job, is to know what you want. So therefore, it's really important that you name someone to be your proxy that knows your situation. You just don't flippantly say, well, my daughter or my son or my sister. They need to know what you want.
So this all comes back to the first session that we had on the family meeting. All of this should be documented. Everyone there should see it, be talked about, so that
they all should know what's happening and who's responsible for what. And that happens inside the family meeting, so that everyone can ask questions and find out who's doing what and what does this mean and how do we handle this. They know each person's job. They know who the executor is, what their job is. They know who has the durable power of attorney, what their job is. They know the healthcare proxy and what their job is, so that they can all work together. And they could be different people in each case, or they might be the same person. It depends upon the relationship you have with those people as to what their job is.
Now, did you say that if you've got this signed and notarized or such, it was a legal document?
In some states it needs to be notarized, but in just about every state, as long as you have 2 people as witnesses and you sign it, it becomes a legal document. As a healthcare proxy.
As a healthcare proxy.
Not a living will, because the living will in itself is not a legal document.
Okay, the living will as opposed to a will. Okay, we talked about a will that you get an attorney to help you draw up. That's a legal document, right?
Yes, it is.
Okay.
Yes, it is.
This is a legal document. So
Yes, it
what's the
is.
difference other than the legality of a living will and a will?
The living will, all the living will does is state your intentions. It does not require the law to comply with them. One of the interesting things that I discovered was, if you ever need emergency medical care, and emergency medical technicians come into your house, and they don't have what's called a DNR, a do not resuscitate form, that's legally immediately displayed, they will resuscitate. They will try to bring that person back to life by helping them to breathe. But if there is something called a do not resuscitate form that has been signed and documented by a doctor, in addition to the person, and they see that, and the family has decided that they don't want that person to be resuscitated, they will not. But otherwise, they will automatically resuscitate. And one of the things I learned from an emergency technician was the place you want to keep that DNR form is on your refrigerator.
Really?
That's the first place they look. When they come into your house, they will look on the refrigerator and see if there's a DNR form.
Where do you get this form?
Well, it's in each state. It's online. You can get it online from the state government, and it's interesting because several states have different forms. For example, in Arizona, the DNR form has to be on orange paper. If it's not on orange paper, it's not legal. It's not legal. And different states have different color forms. So you download that form, and it's signed by a doctor and by the person or their healthcare proxy. It actually is effective in law.
Wow.
Because
Okay.
otherwise, emergency technicians are going to keep you alive no matter what.
Yeah.
Now, one of the other things that I didn't mention in the book that I discovered afterwards is something called the File of Life. This is a simple little form that, again, it has a magnet on the back, and it is a simple summary of your medical information.
Oh.
It has your blood type, it has the type of drugs that you take, it has your doctor's name, it has previous medical conditions that you have, it has your medical insurance, it has your emergency contacts, and it folds up in this little form that you put, again, on your refrigerator. And if the emergency technicians come in, they can find this. I remember one situation where a very good friend of mine, who now lives in Vermont, and I was on Cape Cod, he called me up and he said, "Bob, my mom is really sick, and my dad's there with her, but he really can't take care of her. Would you go over and see what's happening?" And their home was about 10 minutes away from my home. So I went over to their home. Dad was in his early 90s, and Mom was in her late 80s. And Dad was sitting in the kitchen, really kind of confused and didn't know what to do. And Mom was in the bedroom in severe pain. So I called 911. Within 5 minutes, the emergency technicians arrived, came into the door, 3 of them. One of them came to us, myself and her husband. The other 2 went in the bedroom to take care of her. Mm-hmm. The technician who came to us started asking questions. What blood type is she? What's her medical insurance? What drugs is she taking? Questions like that. What's her medical condition? I didn't have any of the answers, and her husband was confused. So I immediately called my friend in Vermont, and he said, "Well, I think she keeps all that information in her pocketbook." And I didn't know where her pocketbook was, and I didn't have that information. So within minutes, they had her in the ambulance and off to the hospital, but it took them a long time to get all that information. Whereas if we had the File of Life right there, could have handed him that, and we'd have it all there in front of us. So this is also available online.
I was going to ask you,
like
where?
75 cents.
Yeah.
File, F-I-L-E,
Yeah.
O Life, L-I-F-E. FileOLife.org.
.org.
It's a very interesting website too that talks about the importance of this information. But it's all right there in this simple little form.
Great idea.
And it's available, and I keep it with me. Wherever I go, I have mine with me at all times. Yeah. So that's very valuable in itself, in addition to things like the DNR. For everyone else, it's a great place to keep all your information together. Yeah. So that's the primary legal documents that we mentioned.
I wanted to ask you about beneficiaries. I had mentioned to you that my life insurance policy, my beneficiary is my deceased father, and I promise you I'm going to get that changed. But somebody told me that, like, my IRAs, if I leave my IRAs to my wife, but I have a different beneficiary, what takes precedence? I don't understand that.
Your retirement accounts, any retirement account that you have, does not pass through the will. Okay. You can't specify in your will, I want my IRA account to go to my wife. The only indicator of where your retirement account goes is the beneficiary statement of your retirement account.
Okay.
And every retirement account that you might have, whether it be an IRA, a 401k plan, a pension plan, each one of them has a beneficiary. And again, it can have a primary beneficiary and a contingent beneficiary. So if the primary person is no longer alive, it goes to the contingent. And it's important to keep that information available. I had one situation where it was really a very unfortunate situation where a client of mine, both of her parents were attorneys, and they both had retirement accounts, and each of them named each other as the primary beneficiary of their retirement account, but named my client, the daughter, as the contingent beneficiary.
Okay.
Unfortunately, they were driving home from New York into Connecticut, fell asleep, drove off the road, and both of them were killed in an accident. My client could not get access to the funds because she could not find the beneficiary statements to those retirement accounts.
Okay.
She discovered that the original accounts were set up with one bank that was purchased by another bank that was purchased by another bank, and 4 iterations later, a 5th bank owned the retirement accounts. It took her 6 months to get that information. So what that indicated to me was how important it is to keep those beneficiary statements available for your retirement accounts. And again, I use the life folio in the back of my book to indicate where those beneficiary statements are and who the beneficiaries are for the life insurance policies. But any beneficiary statement you have is a legal document.
Okay.
And you can change it. While you are alive, you can change any of your beneficiaries to any person you want and do that at any time.
Now, what about let's say I have a taxable, not a retirement account, just a brokerage account, okay? I don't remember ever putting a beneficiary down in a taxable brokerage account.
There are types of accounts that you can specify that are payable on death accounts, both with bank accounts and with securities accounts, that you can specify a specific person to be the beneficiary, one person to be the beneficiary of that account. And I think it's called payable on death.
Where do I get this?
That through whatever investment firm you work with. Tell them, I would like to make this account a payable on death account so that if I die, it goes automatically to my survivor. Now, if you don't specify that and you have an individual account in your name, it goes into your probate estate. It becomes a probatable asset, like any bank accounts that you have in your personal name. All those go into your probate estate and then go through the probate process, which can take 9 months or longer.
Now, can't you put those kinds of accounts, specify in your will who gets them? Or is
no, you can't do that.
Oh, boy.
No, you can't do that. It has to be one of two ways. Either in that process or, and something we haven't discussed yet is something called a living trust.
Right, what's that?
A living trust, a trust is like a separate entity that you set up, and you can be the donor, and you can identify people to be the beneficiaries. You can be the trustee, or you can have other people be the trustee. But what many people will do, if they have a number of different assets, they will change the owner of those assets to their living trust.
Okay.
They still have control over it.
Okay.
They still own it, and they can still do anything they want with it, but it's in a separate a place. It's called a trust, and it's called a living trust.
All right.
It still is included in their estate for estate tax purposes, but it does not go through probate.
All right.
So let's say you had investment accounts, you had property in another state, you had automobiles, you had collections. You can change their ownership to the living trust and then specify who the beneficiaries of that trust are. So those assets would automatically go to the beneficiaries of your living trust when you passed away.
All right. Well, thank you for that one. And I think we've got one more broadcast to come, and that's going to focus on health, the health issues.
Very important area.
I know.